Sitting quietly on set with us is Attorney at Law Martin George. Good morning, Martin George. Thank you for joining us.
Good morning.
Good morning to you both. It's a pleasure to be here. That's a very interesting coffee cup.
Oh, yes,
Yes, it is.
You know, media.
That's a cue, though, for coffee, by the way.
You certainly would have remembered that, so.
Yes, certainly. Yes. And, it's definitely a tragedy that the younger generation doesn't know about her, because the point is she nurtured so many young careers
Rachel
and brought so
Montano.
many people into the spotlight. And, the thing is, this is the kind of mentoring that we sometimes need in the society more and more today.
Yeah, so we're looking at that. Well, a difficult segue onto one of the big topics of conversation in the last 2 or so weeks. As they quoted in many of the blogs, the president versus Rachel Price, and we wanted to explore the issue of slander and libel in Trinidad and Tobago. But first, I just want to ask a question. For clarification and for accuracy, what is a pre-action protocol letter?
Pre-action protocol letter is a requirement of the Civil Proceedings Rules 1998, whereby it requires that you must first send correspondence to someone before initiating legal action in the High Court. You must give them the opportunity to fully meet and treat with your claim, your allegations, and you must also give them the opportunity to respond and, if necessary, to settle the matter so that you avoid unnecessary litigation. So it was a requirement that was put in as part of the new rules, as part of the management of the court's procedure. So it's a very important thing, and when it comes to defamation, there are very specific requirements within the CPR, Civil Proceedings Rules, right, which deal with how you state a defamation claim. You must, for instance, say exactly what it is in the publication that you consider defamatory, and you must give your reasons why. So therefore, you have very specific and precise requirements that you must fulfill within the CPR to satisfy the requirements of the pre-action protocol letter in defamation cases.
But what happens if the pre-action protocol letter is issued, but it's not received?
Well, if you don't receive it, then
There's nothing to answer.
it makes it difficult for you to divine or
as
guess.
Ms. Price has claimed. So with that said, then what is the normal mechanism for delivering that? Is it delivered in person? Can it be mailed, etc.?
Well, the thing is, I guess mailing is possible, but the thing is, in those circumstances, you would always make sure, most attorneys would therefore make sure that you do it by registered mail, so there's some evidence of a receipt. Otherwise, you employ the services of a process server who would then try to serve personally on the individuals.
Let's talk about, there's a difference between defamation, of course, one is printed, one is electronic, and libel and slander, and the differences in those two.
Okay, defamation is the overall cause of action. So that's the overall tort. So in other words, defamation is the injury to someone's character, credit, reputation, right, which causes them to be lowered in the estimation of right-thinking members of society. Now, there's the reason for the caveat. The reason for the caveat is because when you consider, say for instance, if someone says that, look, this person is from Mars, all right, nobody might take that seriously. So therefore, that's why they say within, to be lowered within the estimation of right-thinking members of the society. Now, you must have the actual words that are either said or printed. Now, if it's spoken word, then that's slander. If it's printed word, then that's libel. You must have the publication. In other words, it must be published. I can't defame you to yourself. So if Nicole and I are standing quietly talking to ourselves, between ourselves, and no one else is hearing, and it's never repeated to anyone else or published or broadcast anywhere, whatever is said, neither of us can defame each other to the other. I can't defame you to yourself. Because, in other words, it must be something that causes damage by you being lowered in the estimation of others. Okay? So you can't defame someone to themselves. So that's why the publication is important. So therefore, you look at the means of publication, and I can tell you, Paul, the law of defamation is getting so interesting because it's now expanded to internet.
Yeah.
Right? There's the case of Emile Elias and NH International versus Eugene Reynald in this jurisdiction, whereby statements were made on the internet And as a result, the court was able to make a finding to say, look, that was defamatory because it was published and broadcast to persons across the internet. So we have to be careful because, sometimes persons on the blogs tend to get carried away and they think that, well, it's just freedom of expression. But we must always balance our rights with our responsibilities. And that's all we really need to build a better society in Trinidad and Tobago, The point is, I must respect your rights, but the point is, with that comes responsibilities. It can't be an unfettered right. And the responsibility is the balancing factor. And I think that is what I think has been lost in this entire scenario that has caused it to spin out of control that way. We had also the recent case of Faik Mohammed versus the ILP leader, whereby he was awarded a sum in excess of 200,000 by Justice Kokaram. And there, what you had is that the ILP leader had indicated publicly that this councillor had received $2.5 million from the ruling party, the UNC, to change his vote at the borough council. And there was no proof. So in other words, there must be the statement, it must be proven to be untrue, because a valid defense to defamation is if it's true. So in other words, if the ILP leader were, for instance, to bring evidence to the court to say, well, look, yes, this is the check, this is where he cashed it, etc., then that would have been a valid defense. So truth is always your first defense to any claim for defamation. If it's not true, then you have things like qualified privilege and you have general privilege. Privilege, like for instance, the communications in Parliament, whereby you say they have parliamentary protection. So therefore you have that. You also have privilege in terms of communications between an attorney and a client. So in other words, if an attorney writes a letter to someone and says, look, my client says you are doing A, B, C, D, E, none of what is alleged there can be held to be defamatory against the recipient, because that's part of privileged communication between the attorney and his client. So you have areas whereby you can mount a defense. There's also the area where you can say, look, this is fair comment in the public interest. Now that is always very difficult to define and to draw the boundaries as to what is fair comment as opposed to unfair comment. You had, for instance, the matters between Professor Courtney Bartholomew and another colleague of his in the medical profession, where they were basically, trading barbs publicly, against each other. And, the question was, well, what is fair comment in terms of being able to respond on a medical issue of public interest, or is it that you now cross the line and you are now attacking someone personally? So fair comment is a possibility, but of course that now depends on how the court assesses it. In other words, is it a matter of public interest and public information and education? Say, for instance, if there's a big contract, a big government contract, and someone alleges corruption, and they have some basis for saying so, and there's discussion on that. Now, the point is, because the public interest is at stake, a court may say, well, look, even though it has turned out that some of the statements are not true, it was done in the general interest of the public and on the basis of fair comment. But if it's not, then of course it can become personal. If you recall the case of Conrad Aliang versus the Trinidad and Tobago Express Newspapers Limited and Kamini Mirage and others, whereby he said, look, this has gone beyond anything that you could consider fair comment, because there was a series, I think, of 8 articles or so that were published, in sequence, and which now tended to give a more personalized nature. And therefore, once the court finds that, and they find that it goes beyond the boundary of what is fair and reasonable comment in the public interest, so in other words, there must always be a public element interest. It can't be something personal between two persons that you decide to air publicly and say this is in the public's interest. There must be some genuine public interest element in it.
For the benefit of our viewers, where do we draw the line, though, especially with respect to social media, when you have a public figure and you have thousands upon thousands of persons making not so positive comments about a particular individual, is that defamatory? Is that fair comment? Especially in light of what's taking place now with comedian Rachel Price and the president.
Okay, now you see that's the thing. Now, in terms of the comments made by persons, you have to be careful in terms of what you see. But then the point is, if an issue has now, blown out of proportion and has become a national issue, although I think we have much more important things in Trinidad and Tobago we should be focusing our time and attention on, but if it has become a national issue and persons are making their comments one way or the other, it then becomes difficult to separate and say, well, okay, look, this has gone beyond the pale. Now, if someone has made what is clearly a personal attack, unrelated really to the issue, but they're using the issue as a platform or to stand on a soapbox and to rant against someone personally, then of course that you can easily separate out. But in the general mix of how this has played out, if persons make comments on social media, it's usually difficult to pinpoint one or the other to say, well, look, this has gone beyond the pale, unless, as I say, it so clearly represents an attempt to use the issue for a personal attack against someone.
One of the major questions, though, that a lot of people are asking, why highlight me if I am making particular comments about this individual, but why not highlight the other individuals, the persons on the blogs, the persons forwarding the pictures? Why focus on one individual? Why not basically send a pre-action protocol letter to everybody on Facebook?
No, see, I guess it would depend on what hurts you. Remember, at the end of the day, defamation is something personal to you, the individual. So in other words, 10 persons might comment, but what one person in particular says might hurt you personally. So therefore, you now say, well, look, that statement is what I am aggrieved about, and that statement was broadcast to other persons, and it may cause other persons to believe or think that what that person said is true, so therefore I'm focused on that. So it's really your choice as to how you do it. But it draws the point, and I just want to make this point, Paul, that defamation is personal to you. So hence the reason, if you are deceased, you cannot be defamed, as we saw in the case of Selwyn Richardson versus the TNT Mirror. If you recall the situation where the former Attorney General, Selwyn Richardson, had brought his defamation case against the Mirror because of certain allegations as to certain things that they alleged transpired. And midstream in the trial, he departed this life, and that basically brought an end to his defamation case.
How much of a concern is it that, well, as you say, in the national interest, this is somebody who is a public figure, who is married to the highest office holder in the land, and that the statements are being made not one-to-one, not on a blog, but by an individual on a broadcast medium or through a broadcast medium, reaching thousands of people, presumably. And does that make a difference if that statement, because I think one of the caveats is that it had been repeated for several days or for a period of time, as opposed to, as you say, a one-off comment like any other citizen would have the option to make, not being in that position in electronic media, to constantly make a statement like that. And does that make a difference?
Okay, now the thing is, I think what we have to be careful of, Paul, is to distinguish something said to a person and something said to an office holder. Now, I've checked the Constitution, and I don't think there's an office in Trinidad and Tobago of wife of the president. If you understand,
there's no first lady in our Constitution,
that's
as we commonly make that mistake.
You know? So, I mean, of course, the title is there gratuitously, bestowed, but the point is, officially, if we are to get legal, then there's no office. So in other words...
So that's a private citizen.
This is how it has to be viewed. Now, the point is, the court is not going to deprive itself of the contextuality of the scenario to say, well, look, okay, you're just an ordinary private citizen. Of course you're not. But the point is, the action, if you are to bring it, must be, in my respectful view, in your capacity individually, and of course you then put it into the context that, look, it has caused me more harm than the ordinary citizen because of the position where I am in society.
Well, let me push you into a little controversial matter here. If I'm not mistaken, and from what I've read, I don't know how credible they are, but a statement was forwarded that it's a protection of the office of the president. Can that be justified, given what you've just said?
Well, the thing is, from what I understand, and of course I'm always very respectful to my seniors, I have heard that it was on the advice of senior counsel. So I don't know what information would have actuated the advice or what senior counsel may have had before him or her, in proffering that advice. But on the face of it, it seems that we need to separate the quote-unquote office of the president from a personal scenario which might affect or upset the office holder of the presidency.
But not officially the office.
This is, my respectful view, but as I say, I am not aware of what facts were presented to senior counsel to base whatever advice was given. But, we must always make that distinction because, you see, Paul, in other countries, persons make comments all the time. The comedians in the US, they have a field. They respect no one.
No one.
Joan Rivers, there's no one. There's no one of significance that Joan Rivers,
including the president,
didn't wash her mouth on, and she did it repeatedly. The comedians, in their stand-up routines, they do that all the time. So, in other words, we have to balance our roles as public figures with a bit of understanding that, look, in the nature of things, people can make comments. But of course, as I say, if it is that you feel that this has crossed the line as a personal attack,
you have
and
a right.
not just a comment on something which affects the nation, because you see, there's that also. Because if it is that you're talking about a scenario where someone may be representing at a formal function, then it really becomes dicey to make a clear-cut case. In my
that is
mind,
not in the
as I
national
see it.
interest. Martin George, thanks for being with us.
Thank you so
It's
much.
always a pleasure.
I like how
It's
you
always a
walk the
pleasure to
line
be here.
carefully.
Yes.
All right, we're going to take a break from this.
I just mentioned the last case, Dr. Keith Rowley versus Michael Anisette. That was something where he, a public figure, he made a claim against Mr. Michael Anisette, saying that, look, the statements made by Mr. Anisette were defamatory, and he was successful in that matter.
Thank you so much, Martin George.
Always a pleasure.
Attorney at law. We're looking at libel and defamatory comments. It's time now for us to take a look at the headlines making news at this time.